and we have filed a list and bundle of authorities. And for that matter, I need not take too much time, but only to emphasize this, my lord. If you look at the application by the seventh plaintiff, it is brought under Article 165, sub-Article 4 of the Constitution. Those are the provisions of the law that he seeks to rely on. And because he has chosen that path, the plaintiff must comply with the requirements as pointed out by my learned friend, Senior Counsel Kimani Kiragu, with Article 165, sub-Article 4, and more importantly, sub-Article 3. My lord, in the judgment of Odunga, in a case we have cited, and it is found in paragraph 5 of our written submissions, the Republic versus the President and 5 others, ex parte Wilfrida Itolondo. Judge Odunga states quite clearly that for an application of this nature to find favor with the court, the applicant must demonstrate that the application falls within the 2 categories mentioned in Article 165(3). That is, there must be an alleged violation or denial or infringement or threat to the Bill of Rights. And secondly, and if I'm speaking broadly, the second category is that it must respect, the question must be in respect of the interpretation of the Constitution. Looking at the motion, and there's a notice of motion and the affidavit in support, no such case is made out. And to that extent, my lord, you need not concern yourself with the question as to whether the matter is complex, or whether it brings a novel issue, or whether the question is moot. Those considerations, or because it raises a matter of public interest, those considerations can only come to play if the applicant can demonstrate that there has been a denial or violation of the Bill of Rights, or there's a question of interpretation of the Constitution. Now, my lord, if you look at the motion itself and the supporting affidavit, the question, the substantial question is not brought out, it's not crystallized in the motion. And all that the applicant was doing is go through the pleadings. It is important to mention that actually the applicant doesn't have a claim, but he was going through the pleadings to try and bring out issues contained in the pleadings. But for such an application to find favor with the court, the litigant must crystallize the substantial question. So as you make that decision, it's clear that what is the substantial question of law involved in relation to Article 165, 3 and 4. And my lord, again, looking at the application, one of the issues that is being brought out in the affidavit, which I find rather worrying, in paragraph 7 of the affidavit, is a backdoor application for your recusal. That's what I can say. It's challenging the integrity of this court. And if I may read out what it says, that in view of the scope and sensitivity of the matter and considering how the matter was transpired by Justice Point for further directions by the presiding judge, it is prudent to shield the court from undue pressure. I find that rather not only amazing, but for a litigant to make such allegations in an affidavit, there must be something more concrete to demonstrate that your lordship needs protection from undue pressure. And that is undue pressure when we are ready to proceed with the application, but it's not undue pressure when orders which they find favor with, like the interim orders. When it comes to the question of interim orders, they're quite happy with what the decision the court has made. Otherwise, they would have wanted to impute that initial decision, just like by a roundabout way, they are trying to question the directions.
But Senior Counsel, I don't think those orders were given in favor of the seven?
They were not given in the seven,
Yeah,
but I'm saying they're quite,
the first to the fifth plaintiff.
yes, but I'm saying they're quite comfortable with those orders.
Okay,
They're quite comfortable with those orders. And nowhere have they stated that those orders were given in error. So, my Lord, without, I don't want to take a lot of time on this. Our submissions are quite clear and quite lengthy on this issue. And this is what in American courts they would call Scotch Act litigation. Just to find a way of postponing litigation, like one application after another. And we have seen a semblance of that type of litigation.
Thank you, Senator. Counsel will consider your submissions.
So I ask the court to dismiss the application.
The other counsels who are opposed.